Okay, recording has started. I'm going to share my screen. Okay, so we've started looking at partnerships. Let me just check quickly. There's a problem here with the student that can't join. I'm going to just bear with me. I'm going to try sending the link again. Okay, we're starting to have a thunderstorm here in the background. I hope it doesn't affect my connectivity. If I suddenly go quiet or whatever, please just shout out to attract my attention. Okay, let's not waste time before it starts raining. So we're looking at partnerships. We've learned that a partnership isn't, in fact, a separate entity like a company or a close corporation. It is, in fact, simply a legal relationship, a contractual relationship between a minimum of two, usually up to 20 people. In order for this contractual relationship to constitute a partnership, there must be three elements that must be met, namely contribution, there must be a joint business, and there must be profit sharing. Put an example there. I just want to copy and paste this quickly because we're going to get back to this. So if these three elements are present, the agreement between the parties, this contractual relationship, will in all likelihood constitute a partnership. Once it is a partnership, there are certain natural legal consequences that will always apply. Like with purchase and sale, there are certain duties that arise. With a lease agreement, there are certain duties that arise. With a partnership, similarly, there are certain duties that will always apply unless they have been expressly excluded. So that is why it is important in any given circumstances to ensure that this is in fact a partnership. Um, this particular provision can, for example, have far-reaching consequences. This general rule that ownership of the contribution is transferred to the partnership. And once ownership is transferred to the partnership, the consequence of this is that upon dissolution, the partners share in the value. I'm going to call it here the partnership fund. We're going to look after I've done this part tonight. Still, we're going to look at the partnership fund. So we had the example when we started when I was explaining this about somebody contributes a car. Let's say Mr. Best contributes his car to the partnership, and he doesn't specify that he's contributing only the use of the car. Year later, the partnership terminates. He was in partnerships, let's say, with Johan Kamati. A year later, the partnership terminates, and Johanna has the right to claim half the value of the car. Even if we're still registered investor's name, she has a legal claim to half value. So you can understand that this can be far-reaching. Now, how do we know that it's a partnership? I've given you an example here because I want to illustrate some. Let's say enters into an agreement with Joni, whereby Joni will conduct a farming business on John's farm. They agree to share all the profits made. Look at that and tell me quickly, do you think there's a partnership? Something. And reaction here. Do you think John and Joni entered into a partnership? What did it
Ms. Hanek, yes, your line is breaking.
Yes.
We hear you for 1 second. For the next second, we can't hear you.
Okay. I'm going to just totally. I'm going to change my Wi-Fi connection quickly. I'm going to be down for a
Okay.
moment.
Okay.
Just wait. I'll be back. Can you hear me?
Yes, ma'am.
Thank you, Wadidida. Thanks, Josephine. Okay, this always happens. My telecom Wi-Fi, the moment there's rain in the background, it goes hectic. So I'm hotspotting now. Just let me know again, please, Wadidida, or anybody else, if I start cutting out. Okay, so let's go back to this example. I gave you the example there. John enters into an agreement with Joni, whereby Joni will conduct a farming business on John's farm. They will share all the profits made from this farming business. Do you think this is a partnership? Do you think this is a partnership? Work with me.
No, ma'am, because it's only one partner that contributed. There was
No,
only a contribution from one side. Or is it not?
no, read carefully.
Mm.
Remember, contribution doesn't have to be property. Contribution can also be labor and work.
Mm-hmm.
So the one is contributing, somebody's chatting in the background. The one party is contributing the farm. The other one is contributing the labor, doing the physical work. There's a joint farming business and they're sharing the profits. Waririra, rethink your answer. Or anybody else, do you think this is a partnership?
Yes, ma'am, it constitutes a partnership because they're sharing profits.
Nandikwa, do you agree?
Yes.
Yes, Miss, I agree.
Okay, now listen to me carefully. So after a couple of years, John and Joni end up having a big fight and decide each of them should go their own way. And Joni turns around and says, well, we had a partnership. Waririra said we had a partnership, and Nandikwa confirmed that we have a partnership. The farm is partnership property. I need half. You must pay me half the value of the farm. Do you think John is going to be happy about that?
No, ma'am.
Of course not. He suddenly realizes he has to sell his farm. Now I'm going to make a different suggestion. John turns around and says, no, this was never a partnership. This was a lease agreement, Joni. You leased the farm from me, and the rental you paid was, remember, it's a rural lease. You're allowed to pay in goods, in profits, in produce. John says, nope, we had a lease agreement. You leased the farm from me. And the rental that you paid was half of your income that you earned. Looking at those facts again, Nandikwa, everybody else, do you think that can be a lease agreement? Joni uses the farm, rents the farm. The rental that she pays is the value of half of the income that she earns. That's a lease agreement, don't you think? So are you now confused? That brings us to what we're looking at today, namely the intention to establish a partnership. Because in addition to these three, in addition to the three essential requirements, the parties have the intention to establish a partnership. Now, first of all, before you get too confused, this issue of the intention to establish a partnership is only really relevant if there is a dispute. If they just decided to each go their own way and Joni didn't insist on claiming half the value of the farm, then this bit isn't relevant. But now they are fighting, there is a dispute. So they're fighting. There's a dispute. Pamwe, you did want to say something? Your
No,
mic
ma'am,
was
sorry. The mic was
okay.
just open by accident.
Okay, not to worry. Okay, so in order to establish a partnership, you have to have those three essential elements, those three requirements. In most instances, nobody ever queries whether it's a partnership or not. It's just when there is a dispute. Maybe you based on the same facts. The receiver of revenue, NAMRA, got suspicious because for a partnership, in a partnership agreement, if it's a written agreement, and it doesn't even have to be a written agreement, you pay $20 stamp duty. Lease agreements, however, are based on a percentage of the annual rental, so it can be a huge amount. So they actually entering into a lease agreement, but to avoid paying NAMRA, they color it in as a partnership. And when NAMRA comes to claim their money, they say, no, 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 this is not a lease agreement. This is a partnership. We don't have to pay stamp duty. And NAMRA says, no, you're trying to cheat me. There's a dispute about whether it is a partnership or not. And in solving this dispute, the true intention of the parties, the true intention will determine whether it is a partnership or not. But now you can ask, how do you prove intention? Because obviously, if it was Joni wanting to claim half the value of the farm, and John saying, no, we never intended to enter into this as a lease agreement, they end up in court. Joni says, we intended to form a partnership. John says, no, we didn't intend to enter into a partnership. How does the court go about solving this problem? Because the one is going to say yes, and the other one is going to say no. How do the courts go ahead in approaching a problem like this? Quite simply, by following the following steps. The party is a partnership only needs to prove that the three requirements are present. So Joni, who's saying this is a partnership, all she needs to prove, there was contribution. Easy to prove. There's the farm. She did the work. Joint farming business, and they shared profits. Relatively easy to prove. More difficult for the other party, who disputes the partnership, will have to bring the necessary evidence of some other intention. So this will be more difficult, but not impossible to prove. What you need is need to know is the knowledge items. How do you prove intention? This bit. I will not necessarily ask you this in a case study where you have to decide, because based really on those facts that I gave you there, it isn't actually possible to come to a complete conclusion about whether this is a partnership or not. We would need a lot of additional information to come to some conclusion based on this. These facts are too sparse. I made that like that in practice to actually decide what was the true intention here. I'm not asking you to be the judge. I'm asking you to know which steps will the court take if they are confronted with a problem like this. Any questions? Okay, moving on then. And this is important because there are some questions about this in the exam. I think it's just a multiple choice question, but whatever. The partnership fund. Even though the partnership is not regarded as an entity, our law does recognize the existence of the partnership fund. What constitutes the partnership fund? What goes into the partnership fund? Contributions, if they were property. Obviously, if the contribution is labor, it doesn't go into the partnership fund. But any property contributed goes into the partnership fund. Property acquired, so anything that the partnership has purchased during the existence of the partnership. Profits made, loans obtained, goodwill of the partnership business, property used. For the proper functioning of the business. That is the partnership fund. Now, it is important to know, why is it important? To know particular asset. Part of the partnership fund. So this car that Ryan contributed, it is important to establish whether this car is part of the partnership fund or not. Why is it important? Two reasons why it's important. Firstly, for outsiders. We learned last week that a partnership is not a juristic person, does not have legal personality, and that ultimately the partners are personally liable for the debts of the partnership. However, this liability only arises if there is nothing left in the partnership fund, if it has been emptied out by creditors. If a creditor has a debt, a claim against the partnership, let's say our partners here are Queen and Stacy, and Christina's the creditor, Christine, when she wants to collect her debt, must firstly attach whatever is in the partnership fund. Only once that is depleted can she hold Queen and Stacy personally liable. Exactly how that happens, we will look at a later stage. So for third parties, for Christine, it would be important to know this vehicle that was contributed, is it part of the partnership fund? Because if it is, she can attach and sell the vehicle. For the partners themselves, it is similarly important. But it only becomes important upon the dissolution of the partnership. Upon the dissolution of the partnership, whatever remains, the free is referred to as the free residue. What remains in the fund is shared. So that is why it's important during the existence of the partnership for the purpose of creditors, whether they can attach a specific asset or not. Upon dissolution, important for the partners or the former partners, whether they can claim a share or not. Now, how do we determine this? How do we establish? And this is only really relevant with regard to contributions. Property acquired during existence of the partnership and profits, whatever, that's obvious that it forms part of the partnership fund. So we're really referring to these contributions. Do they form part of the partnership fund or not? How do we determine this? It depends on who is asking the question, who wants to know. For outsiders, there must be formal transfer. So if Ryan's car was never transferred to the partnership, it's still registered on his personal name. From the point of view of creditors, third parties, outsiders, they will not be able to attach his car. But between partners, it works differently. Between partners, no formal transfer required. Is required. What matters is the intention of the parties. And that brings us back to this very important thing that I said here, that the general rule is, so in the absence of a clear express intention, the general rule will apply. And the asset, the car, whether it is still registered on Ryan's name or not, will be regarded as part of the partnership fund, which means the other partners can share in the value. Questions? Is everybody with me? Are you starting to understand and realize? Ronald? Ronald, your hand was up. Oh, that's the thumbs up, so you do understand. Great. Are you starting to realize, people, that partnerships are great. Partnerships are wonderful. I'm not saying never go into a partnership, But if you enter into a partnership with the intention that this, I'm not saying selling once-off sandwiches on the NAS campus to make some money, but if you're intending to enter into a partnership in the long term with the intention of making a lot of money, make sure that all these things are sorted out before the partnership commences. Because if you go into it without having proper knowledge, going into it head over heels, you might eventually, when you start fighting with each other, realize that it had very, very far-reaching consequences. As we carry on with our study of partnerships, we're going to come across even more of those. But this is one of them. Whatever you contribute forms part of the partnership fund, whether it is formally transferred to the partnership or not, unless there's a clear intention referring back to the commencement of the partnership. Doesn't help if Ryan now suddenly jumps up and says, no, I never intended. Too late. Okay, everybody with me? Okay, and then the extent of each partner's share. How big is each? I've been referring to sorry, where am I now? I've been referring to sharing what remains in the fund is shared. How do we know? How much does everybody get? First of all, the extent of the partner's share is not relevant during the existence of the partnership. Only becomes relevant when we're getting to that bit to determine how much must everybody get. How do we determine what is the extent of each partner's share? It is determined in terms of their agreement. It does not have to be equal. So it's not a fact that if there's two partners, each of them will always get 50%. It depends literally on the agreement. If there's no agreement, you will look at the profit sharing ratio. How the profit sharing ratio is determined, we study in the next unit. Any questions? Yeah, I'm just looking at my notes here. Just give me a minute to collect my thoughts. Okay. Last thing that we're doing then tonight is types of partnerships. Our law recognizes different types of partnerships. We only look at three types actually of partnerships. Firstly, our law distinguishes between ordinary and extraordinary partners. So an ordinary partner is literally what we've been spoken or been talking about so far. Oh, my spelling. Ordinary partner contributes, participates in the business, and shares in profits and losses. So that is an ordinary partner. They do what everybody normally does, what we've learned so far about partners. An extraordinary partner. The English word extraordinary, different from the ordinary. When is a partner an extraordinary partner? Extraordinary partner contributes and shares in the profits. Does not participate. Does not participate openly. Does not participate in, let's call it, management. This does not mean that they have got absolutely nothing to do with the business. They can still consult with the other partners, give them advice, whatever, but they do not they don't deal with outsiders. And in exchange for not participating, they do don't share in the losses. So that is what the big difference is between ordinary partners and extraordinary partners. Extraordinary partners, they're not liable to that was wrong. That was wrong. I cannot say do not share in the losses. They are not liable to third parties. So if my partners are Queen, Pamwe, and Albertina, and my creditor is Hedwig, Albertina is an extraordinary partner. Now Hedwig has a claim and she's depleted the partnership fund. She can collect whatever is still due from her or to her, either from Queen or from Pamwe, but not from Albertina. If Pamwe has paid, he can collect a share from Albertina, but Hedwig can't claim everything from, she's protected. Hedwig can't take her to court. Hedwig can claim the full amount from Queen or from Pamwe or from both of them together, not from Albertina. If they've paid, they can get a share back from Albertina. But of course, if she doesn't have anything, you can't get blood out of a stone. Then she doesn't pay. So extraordinary partners protected from claims by third parties, and they don't participate in the business. Now we get two types of extraordinary partners. Firstly, you get a silent partner. Silent partner is an extraordinary partner. They contribute. They don't deal with outsiders. They're not liable to third parties. With regard to their profit sharing, make it profit and loss. That will be done according to the agreed profit sharing liability agreement of the partners. So if there are 3 partners and they agree that they are equal partners, but the one is who was my extraordinary partner here. Albertina was the extraordinary partner. So we've got Queen, Pamwe, and Albertina. They agree on an equal share, so 33, but 1/3 each. Albertina will get 1/3 of whatever profits are made. If there are debts to be paid, she will be liable for 1/3, except that outside creditors cannot claim that from her. But Pamwe and Queen will be able to claim back her share. So profit and loss sharing done pro rata according to their agreed profit sharing. The other type of extraordinary partnership that we get, this is a French word. A partnership en commandie. Fortunately, you don't do oral exams, so you don't have to pronounce en commandie, also known as a commandatarian. Partner. Now, where a silent partner and a commandatarian partner differs, they are the same in the sense that they contribute and they don't participate in the management. They don't deal with outsiders. Commandatarian partner, however, when it comes to losses, they are only liable to the amount of their agreed contribution. So if Albertina has contributed $100,000 and eventually the whole thing goes pear-shaped, and there are a further 200,000 debts outstanding, she's not held liable for by outside parties, by third parties, and she's only liable for the 100,000 that she has now, in fact, also already lost. Because the whole thing, there's no money left, so she lost her contribution. She's not getting anything out. But she doesn't have to pay anything additional. Now, you might think, but okay, then why would somebody want to be a silent partner and not a commandatarian partner? Because there's always a flip side of the coin. Only liable to the amount of the agreed contribution, but in exchange for that, They only share in their profit up to an agreed amount. So it's an extraordinary partner. If they made $300,000 profit, each of them would get, or let's say 600,000 profit. Each of them will get 200,000. Partnership on commandee, her potential losses are limited, but her profit is also only limited. So if they agreed to a maximum of 100,000 profit, they make 600, she gets 100,000, and the other 500 is shared between the other partners. So there's an upside and a downside to either these arrangements, these types of extraordinary partnerships. It depends literally on whether the partnership is profitable or not. If it's profitable, it's better to be a silent partner. But the moment it starts running into financial problems, it might be better to actually be a commanditaire. But of course, you can't change it halfway through. These are things that are decided at the formation of the partnership. Last thing to be said about extraordinary partnerships. This bit. So, commandatarian extraordinary partners are protected against liabilities from third parties. They're not liable to third parties. Let's just put this in for the sake of completeness. In exchange, they don't participate. They don't deal with outsiders. If they do, they lose their protection. So if Albertina was an extraordinary partner, but she enters into a contract with Christine, she loses her protection as extraordinary partner and will subsequently be treated like an ordinary partner. Any further questions? We've done, that is all we need to do for tonight. Waririra is happy. I'm happy that Waririra is happy. Roland is happy. I'm happy that Roland and Pamwe and Albertina and Hedwig, I'm happy that you're all happy. I hope it's raining wherever you live as well. Lloyda, thank you. Wonderful. Thank you for joining. It's Friday tomorrow. If you're writing tests over the weekend, I wish you the best of luck. If you're traveling anywhere, please stay safe. Thank you. Bye.